Good morning, ladies and gentlemen. Just checking. It's good evening. Welcome to the EthiQal webinar. My name is Hlombe Makuluma. I am the medical legal advisor for EthiQal. Primary training, medical doctor, GP. Secondary training, medical law. Not a lawyer, but I've just done a little bit of medical law. Welcome to the webinar. At EthiQal, we run the series of webinars. There's probably another one that will come later in the year. This webinar has got 2 ethics points, and it has become very important now that you attend the full session because HPCSA is getting stricter and stricter in terms of ensuring that people don't just register and go in for 20 minutes and then they disappear. But for those of you who may not be able to complete the session for various reasons, the presentation itself will be uploaded in our website, ethical.co.za, in about 10 days' time. So you can go back to the site and you can complete the attendance, and you will be able to earn your ethics points from the website. Just a few things going forward in terms of how the proceedings would be like. At the bottom of your screens, please use the Q&A, the question and answer button. If you have any question that you want to ask as the presenters are presenting, we will be able to some of those questions address while the presentation is going on. At the end, there'll be a formal session again of a Q&A. But again, even there, preferably, let's write our questions. There were questions that were sent before, when you registered. There were questions that were sent. Some of those questions will be addressed during the presentation. Others will be able to address them, as we do the Q&A. And to our presenters is Ms. Mashuma Parker and Ms. Jessica Falloon. They're both admitted attorneys. They both work full-time for EthiQal. They are our legal advisors with EthiQal. Without wasting a lot of our time, I'm just checking if is there anything that I've left that I need to ensure that I address. No. Let's welcome Mashuma and Jessica. Thank you.
My name is Mashuma Parker, and my colleague who you will meet shortly is Jessica Falloon. We are both legal advisors and admitted attorneys that sits in the claims team at EthiQal. And we thank you for taking time out of your busy schedules to join us for this presentation. By way of a quick look at the structure of the talk has been divided into 2 parts. The first part will deal with adequate record keeping, which will be dealt with by myself. And the second part of the talk will be dealt with by Jessica, dealing with accessing of patient information. In the first part of the talk, my objective is to work you through what Booklet 9 of the HPCSA's ethical guidelines prescribes should be contained in your records. I will also work through some guiding principles that the guideline prescribes your records need to adhere to. We'll then work through some practical illustrations of why this is important before asking some commonly asked questions. I will then hand over to Jessica. She will deal with the accessing of patient information. She'll work through this question of where ownership of patient records lie. Thereafter, she will inform you of everything that you need to know when receiving requests for records. She'll then work through a useful checklist on the topic prior to working through some practical examples before concluding. So as mentioned, booklet 9 of the HPCSA's ethical guidelines is the booklet of relevance when dealing with patient records. In terms of booklet 9, a patient health record is defined as being a longitudinal collection of an individual's personal or health information that is recorded either by you as the healthcare practitioner or by somebody else at your directive. And this is so regardless of the form or the medium that that information is recorded in. It is an undeniable fact that good quality health records is an essential component for the safe and effective practice of medicine, as it not only facilitates continuity of care and promotes good clinical practice, but it also aims to protect you as a legal practitioner you as a medical practitioner against medical legal exposure. Here, we believe that if you are able to maintain meticulous records, that is, records that are complete, that are comprehensive, they're unambiguous, they have integrity, and they are accurate, that it places you in a good position to later down the line rely on those records in order to substantiate the reasonableness of the treatment that you provided to your patient. And in doing so, it puts you in a comfortable position to refute any allegations of either unprofessional, unethical, or unreasonable conduct that's lodged against you. Whether these come to you in the form of a direct patient complaint, whether that comes to you via your HPCSA's disciplinary process, or alternatively via litigation, we believe that you'd be in a better position than if you were reliant on poor record keeping to mount your defense. Conversely, we also believe that not only does poor record keeping jeopardize patient safety, but it also exposes you to legal repercussions and the possibility of the implication of sanctions by your regulator for non-compliance with your legal and your ethical obligations. By way of practically illustrating the importance of this, and besides noting the importance of and the highly publicized increase in med-mal litigation. If we can move to the next slide, please. What you'll note on that slide is the HPCSA's annual stats for the 2023 year. What is interesting on this slide is that there were 1,675 complaints lodged against practitioners for that year. And although, as can be seen from that slide, only 44 of those related directly to patient complaints, it's not difficult to understand how all 1,675 of those practitioners needed to rely on their records in order to substantiate the treatment that they provided to the patient. They also then, or alternatively, needed to note any deviations from the standard of reasonableness and then to try and mitigate against any adverse findings. It's on this basis that we believe that if you intend to sustain a long-term practice of medicine with at least some ease of mind, then perhaps quality health records is your best place to start. What you see on this slide is an extract that I've cut and pasted from the booklet 9. It really includes what the guideline prescribes the compulsory elements of your records are. And I am, however, not going to regurgitate this. You can refer to it at your leisure. Instead, the guideline also includes multiple other lists. And for purposes of this talk, I've prepared a combination of these lists that I'm hoping to present to you in both a logical way that is easy for you to remember. If we can please move on to the next slide. Thank you very much. So as mentioned, before we actually dive into this list, at EthiQal, we deal with retrospectively with healthcare practitioners' records on a daily basis. And I thought it might be useful when dealing with this topic of adequate record keeping to suggest that you keep at least one of two long-term objectives in mind when approaching record keeping. Either you're drafting your records so that you can make it accessible to another healthcare practitioner after your treatment has ended, so that that healthcare practitioner can note all material information involved in your treatment and management of the patient, and that will allow them to safely continue the care of that patient without having access to you. Alternatively, what you can do is to keep another objective in mind. is after the fact, after your treatment has ended, you need to provide a copy of your patient records to your legal representative, who will need to reconstruct the treatment and management that you provided to your patient in order to chronologically set it out to substantiate the reasonableness thereof, the professionalism thereof, as well as the ethical nature thereof. Your records will then be used as evidence either in your favor, or alternatively, it will be any deviations from such standards will be noted, which means that you will need to take advice on how to strategically try and mitigate against any adverse finding. So, getting into the topic, the first important guiding principle is that the guideline prescribes your records must be contemporaneous. This merely means that your records must be entered into at the time of your patient interaction or as soon as possible thereafter. Any late entries must be noted and dated as such, and the reason for the lateness must be recorded in your entries. The guideline prescribes that there are 3 preliminary sort of matters that you need to include in your records. Logically thinking about it, any patient personal identifying information, the date, the time, and the place of the consultation, as well as who's making the entry. Who's making the entry speaks to another important guiding principles that records need to comply with, which is that your records must be attributable to you. It becomes important where there are multiple practitioners entering records into a single record, such as a hospital record. Your record needs to be clearly attributable to you. And how do you do that? Well, you not only sign where you've made an entry, you also write your name in block letters and you include your contact details there under. We know that for purposes of this contact details, your MP number should be sufficient. The last point under these preliminary points is that you need to take a full biopsychosocial history of your patient. This needs to include any allergies and any idiosyncrasies for that particular patient, which needs to prominently be displayed on your records so that it's not missed at a later point. This further speaks to another important guiding principle that your records need to be accessible, or really the information contained in that records need to be accessible when it's necessary so that you can provide safe and effective healthcare to your patients. Once that preliminary information has been attained and it's recorded in your records, we then move on to the clinical assessment, investigations, and a referral stage. Here we know that your medical assessment and findings, what it revealed, needs to be included in your records. Any differential diagnosis and your clinical proposed management plan, if it is at all relevant to you, needs to be included. Any referrals that patient was sent to, whether it is to other healthcare practitioners or to specialists, it's important to note this information in your records. And lastly, any investigations that you sent the patient for. You also need to include copies thereof. And if there was any information or discussion that was fed back to the patient regarding the results, then you need to include that in your records as well. Once you've managed to do this, we move on to the next slide that deals with informed consent discussion. Ideally, what would you as a healthcare practitioner like your records to say? What story would you like it to say? You would like to illustrate that you've provided your patient with sufficient information for them to autonomously decide on their own health. And so your records need to include any information and advice that you provided to your patient regarding your clinical assessment and findings. You then also importantly need to deal with any conservative options or surgical options that you've provided to the patient, the risks, material risks, complications, benefits, cost, and possible including no treatment at all needs to be discussed with the patient. And if at that point the patient has made a decision as to where to from there, include that, as well as if you're able to note the reason for the patient preferring one option as opposed to the other. You also need to note when that decision was made. This is important because a person that needs urgent hip replacement surgery because that person is in so much pain and that patient telling you, "Doc, I can't handle the pain, I need to undergo the procedure, is very different to a patient who says, who you advise, I think one of your options should be a hysterectomy. But thank you for the information, doctor. I will consider my options and I'll make contact with your offices once I'm ready to do so. You also then need to make sure any written affirmations or decisions taken needs to be documented in the form of a written informed consent document that is both dated and signed. Then, any actual treatment that you provided to the patient, this includes treatment that you either administered, whether it's in small procedure, in-room procedures, or alternatively surgical intervention. Your operative note needs to be included in your records. And then by way of miscellaneous matters, we know that medication prescribed and dosages thereof need to be documented in your records. Any patient responses to treatment that you provided or adverse reactions to either treatment or medication needs to be documented in your records. Details of any time that you put the patient off of work or similar activity, as well as your reasons for doing so, should be included. All formal and informal correspondence with the patient, and any progress notes that you noted along the way. This includes all form of correspondence, whether it's text messages, whether it's WhatsApp messages, whether it's emails, or any other form of correspondence. It's best and ideal for you to keep any progress notes relating to that patient in your file. All future appointments and advice that you provided to the patient regarding any change in their symptoms, any deteriorating health and what they need to do, as well as what they would need to do in emergencies, should be documented in your records. Lastly, all correspondence that you had with the patient, including any discussions that you've had with your colleagues. And then what the guideline has or includes, it's this type of catch-all phrase where they say that any other documentation or information of relevance for that particular patient should be included in your records. What we at EthiQal also additionally advise is that you keep a separate folder in your patient folder containing all the financial informed consent documents in your for that patient, so as to always be able to refute any allegations of a lack of informed financial consent, which is actually quite common. So at this point, I quickly want to pause and to state that I actually feel somewhat obligated to pause and to mention that I acknowledge that it's easier for me to sit this side of the fence and to dictate to you these comprehensive lists that you need to comply with. But I do acknowledge that it can appear to be quite onerous and burdensome when you are running a very busy practice. However, it's not my intention to burden you. Instead, what I've mentioned previously is merely what your regulator has prescribed in terms of the EthiQal guidelines. Before working through some practical illustrations of why that information is important and how it can limit your medico-legal exposure, I just want to refer to this slide. This is the 5 guiding principles that I kept alluding to during the talk and probably will still do so going forward. But my intention is not to regurgitate the content that's stated on there. You can refer to it at your leisure. It is contained in the records, in the guideline, and it is quite self-explanatory. Moving on to the practical examples. This first example speaks to your ethical obligation of documenting the details of all discussions that you had with your patients, relating to any existing chronic medication, as well as any doses of medication or subsequent alteration thereto. It was a written complaint that one of our nephrologists received from one of our patients. The patient was questioning the dosage of iron medication, and he alleged that our nephrologist had instructed that she be put on iron drips, but that our nephrologist had not subsequently gone back to stop the existing iron dosage that the patient was already on. He also interestingly mentioned in his letter that you can see on the board is that her notion that she verbally told him to stop the iron medication was actually a fiction. And in this instant, what should have been a very easy issue to resolve with reference to our nephrologist records turned out to be a he said, she said type of situation, which not only unnecessarily prolonged the matter, but understandably caused our practitioner a great deal of stress because she was now unable to evidence her version of the facts. The second example, this speaks to the importance of documenting all discussions that you've had with the patient, whether it is in person, whether it's via the telephone, as well as documenting the referrals to specialists or other healthcare practitioners. It was a very simple HPCS complaint that one of our neurologists received that surprisingly to me actually ended up at a full-blown formal inquiry at the HPCSA. One of the charges against our practitioner was that he poorly communicated with his patients and that he did not formally refer her to a psychiatrist. The complaint ended up dragging on for a few years and understandably caused our neurologist a great deal of stress and wasted time in defending it. Thankfully, however, we were able to successfully defend it. The next example speaks to the importance of documenting any investigations and tests that the patient was sent for and any possible reasons for non-compliance. This relates to an HPCSA complaint that one of our OBGYNs received. It was supported by an unfavorable expert opinion, but unfortunately, it was an unfortunate set of circumstances because the plaintiff's expert did actually not have a copy of our OBGYN's records prior to drafting the opinion. And based on this unfavorable report, not only did it prompt the patient's attorneys to litigate our doctor, but it also later prompted the patient to lodge this HPCSA complaint against him. One of the allegations related to the patient alleging that our doctor failed to send the patient for basic antenatal bloods. However, when we had regard to our insured's records, it was quite evident that on more than one occasion did he actually not only first of all refer the patient to those antenatal tests because it's quite a routine, but he had also inquired from her when he noted that she was non-compliant. The next example is a summons that was received by one of our OBGYNs, and it also speaks to the importance of you documenting your informed consent discussions with the patient. This related to a VBAC delivery where the patient ended up sustaining a tear that later ended up a 4th-degree tear and turned septic. The allegations centered around our insured not making sure that it was appropriate for this patient to be taken for a VBAC, and also an allegation that she did not thoroughly counsel the patient on what the risks and complications were associated with such a VBAC. However, if we move on to the next part of the slide, when we noted or looked at our insured's records, it was quite evident that our insured had clearly discussed the criteria for a VBAC with this patient, that the patient was also quite insistent to undergo a VBAC, but also that she had thoroughly counseled her about the material risks associated with this type of procedure or operation. And as you can see, 4th-degree tear, episiotomy was also discussed, and even possible anal tears, and I think there was sepsis also discussed. Safe to say, there was strong evidence to evidence the reasonableness of our insured's treatment. The next example illustrates, this was also a summons that one of our practitioners received, and it illustrates the importance of keeping copies of the results and investigations that you send your patients for. And then also noting or documenting any discussions or feedback that you've had with the patient on those results. It was also a summons that one of our OBGYNs received, and it was common practice, she mentioned, where she worked, to rely on verbally on information that the laboratory had advised her regarding the outcome of test results. In this particular instance, she was informed that the patient was HIV negative. The baby then went on to be delivered in December. The following year in March, the baby was admitted to hospital. It turned out that the baby was cytomegalovirus positive, and understandably, fingers was now pointed at our insured, alleging that not only did our insured unreasonably rely on information that was telephonically informed to her, not have a copy or a hard copy of those records prior to actually counseling the patient on what to do, that the patient was not then counseled about what she should do to look after her HIV status, and that when the baby was born, this nivaparin was not administered after birth. She was then sued for approximately 5 million. The next example, well, this is not really an example, but I always feel that when it comes to medical questionnaires, that it's always, for some reason, quite undervalued by practitioners, where I feel that it can actually provide you with so much information while the patient has even, before the patient has even started consulting you, while they're waiting for you in your waiting rooms. On one occasion, I know that was an HPCSA complaint that I dealt with this year, where I wasn't able to attain a full medical history from the insured's physical entry. But thankfully, because of questionnaire, I was able to obtain a lot of information, and then thankfully communicate this in my response to the HPCSA, and we were able to receive or get a favorable determination in that matter. The next slide. I'm not going to work through this, but this really speaks to that recommendation of you holding a separate folder for financial informed consent. It's important because what you see on the slide over there is really an extract that the HPCSA's officers usually cut and paste when you're about to read that there was a lack of informed financial consent by the practitioner. And then, of course, it is difficult decisions that you need to make as to what you're going to do then for services that you did render, but because you perhaps you were not able to evidence proper informed financial consent, it put you in a precarious position. Next, I want to refer to some commonly asked questions. And the first question, really, which is on the next slide, the first part of this question relates to the steps that you need to take if an error is identified in your records, while the second part of the question relates to what you need to do if you want to add entries at a later stage. Right? So I've cut and pasted on the board. What do you see over there? It's taken from the guideline, booklet 9. When you note an error in your record, you need to use an ink pen to make a solid line through the original entry, but that contains the error, but that original entry needs to remain legible. The alteration must then also be signed and dated in full, and where possible, you need to refer to the correction without altering that initial entry. Going further, when you adding additional entries to your records at a later stage, just one slide back, please. You need to make sure that you not only date and sign late entries in full, but that such changes must be attributable to you. You must also include the reason for the amendment or the error. If you need to refer back to this, as mentioned, these are the relevant points in the guideline. The next question deals with how do you ensure the privacy and security of your patient records. The guideline is quite detailed to a certain extent when it deals with ensuring the privacy and security of records. It prescribes that you need to prevent unauthorized access of your patient records, whether it is in an electronic or a hard copy format, and regardless of how it is stored, whether it is stored at an actual storage facility, whether it is in your offices, or whether it's on some sort of electronic system or on your PC. You must prevent unauthorized access to those records and prevent improper disclosure thereof. The guideline mentions some ways that you can ensure this protection. And when it comes to storage facilities, it says that you need to ensure restricted and authorized access control. When it comes to electronic data, when it comes to the management, the storage, and the backing up, you need to make sure that you use standards, internationally accepted standards, such as what they quote there in point 6.4, this ISO 27799 of 2016 for information security management in health. When I look this up, it actually is just a world-class standard that is used for privacy and avoiding or protecting against improper disclosure on international standards. The guideline goes further to state that your electronic data must be kept confidential, even when you're undertaking data transmissions and when your information is transferred either between facilities or between different healthcare practitioners. And then lastly, the guideline prescribes that there must be a balance against improper access and disclosure able for you to ensure that you have timely access to your patient records to deliver the safe and effective care of your patients. So the slide we're on now asks the question of what do you need to do to how long do you actually need to retain your records for? And my intention is to actually not regurgitate what's stated on the slide. This information is contained in booklet 9, but perhaps I'll mention a few things. And that is that ideally, the guideline prescribes that your records should be kept indefinitely if it is at all practical and if it can be done in some sort of electronic format. However, if it's not practical, then you need to keep your records for a minimum of 6 years from when that patient file becomes dormant. And here, dormancy starts from when you last provided treatment to the patient. There are, however, certain exceptions that's set out in point 7 over there that you can see. And one of these exceptions relates to care that you provide to patients under the age of 18, which includes obstetric care patients. And really, it dictates that patient health records in this instance should be kept up until the patient's 21st birthday, because as minors, they have 3 years from the date that they become a major, that is 18, to actually claim or lodge a claim or against you as a healthcare practitioner. For mentally incapacitated patients, the health records need to be kept for the duration of that patient's lifetime. When it comes to records that fall under the Occupational Health and Safety Act, you need to retain those records for a minimum of 20 years. And then the guideline prescribes that there are several other factors that could actually prompt you to keep records for a longer period. And this is really to make sure that you allow sufficient time for a patient to have equitable access to care should they require it at a later stage. And by way of example, it speaks to maybe conditions, health conditions that may take longer to present. So, or manifest, such as they say, as this asbestosis. The next point is generally all statutory obligations where it prescribes that you need to keep patient records for a longer period, you'll need to do that. And then the one thing that the guideline lastly says is that you need to balance out the cost of long-term retention of your records, but then also make sure that you balance that with your defense either in a later litigation or complaint. And then they also mentioned that it might be of value in academic research, for academic research purposes and late complications developing. Thank you very much. I will now hand over to my colleague, Jessica, who will deal with the accessing of patient information. Thank you.
Thank you, Mashuma. I am Jessica Viljoen, and I am also an admitted attorney and a legal advisor in the claims team at EthiQal. My portion of the talk will be focusing on access to patient records and requests for patient records and what to do when you as a practitioner receive a request for your patient records. Firstly, the ownership of health records. This is set out also again in HPCSA Ethical Guidelines Booklet 9. And according to Booklet 9, patient health records are owned by the practitioner or the establishment that generates the record. However, patients do have the right to access and obtain the information which is contained in their health records. The right of access to health information and patient health records is in terms of the Constitution, specifically Section 32, which dictates that everyone has the right of access to information that is held by the state or by another person if that information is required in order to exercise or protect any right. This constitutional provision clearly entitles patients to access their own medical records, whether those records are held in a state hospital or a private healthcare facility or held by a medical practitioner in private practice. The Promotion of Access to Information Act, or PIA, was enacted to give legislative effect to this constitutional right. And it is actually the provisions of PIA that make it easier for patients to gain access to the information in their medical records, both in the public and private sectors. The HPCSA ethical guidelines similarly reinforce these applicable laws with regard to the guidelines on the access to information in patient health records. Specifically, Booklet 9 states that a health practitioner shall provide any person of age 12 years or older with a copy or an abstract or direct access to his or her own health records regarding their own medical treatment when requested to do so. However, no healthcare practitioner shall make information available to any third party without the explicit written authorization of the patient themselves, unless an exception exists. According to the HPCSA guidelines, those exceptions would include if a court orders that the patient health records be handed to a third party, or where the third party is a healthcare practitioner who is being sued by a patient and they need access to the records to mount their defense, or where the third party is a healthcare practitioner who's facing disciplinary proceedings by the HPCSA and similarly require access to all the patient's records in order to defend themselves. Where a practitioner is under a statutory obligation to disclose medical facts, such as if there is a suspicion of child abuse in a minor patient, or where the non-disclosure of medical information would represent a serious threat to public health. Moving on to requests for patient records. There are many reasons why a practitioner may receive a request for access to a patient's medical records. Such requests can come from the patient themselves, or from an attorney, or even from another third party, such as an employer, or a financial broker or insurer who's looking for health information. It's important to keep in mind that just because a patient or someone acting on their behalf is requesting copies of their clinical records, it doesn't necessarily mean that they are doing so for purposes of investigating a potential claim against the practitioner. Whilst this obviously may indeed be the case in some instances, other reasons for receiving a request for records could include that the patient wishes to seek a second opinion, or that they're contemplating some other form of litigation in another type of personal injury claim, such as your slip and trip incidents in a supermarket or a claim against the road accident fund. However, it's important to keep in mind that regardless of the reason for the request, the law does give a patient the right to their medical records. So a practitioner is obligated to comply with such a request, whether it's made by the patient him or herself, or by someone who has been duly authorized by the patient to act on their behalf. Some important initial observations to keep in mind are that a patient's relatives do not have an automatic right to access an adult patient's medical records, as much as some spouses and difficult partners may think that they have that right. It's not an automatic right, and they don't. And they still require the written authorization of the patient to access those records. And in the case of patients who are under the age of 16 years, but over the age of 12 years, the parent or guardian may request access to the minor patient's records, but the request still needs to be accompanied by the written authorization of the patient, even though they are a minor. One of the most important things to keep in mind when, as a medical practitioner, one receives a request for patient records is that it is essential to first verify the identity of the person making the request. If it's not the patient themselves, it's imperative to establish whether or not the requester has the authority or the right to access those patient records. We've set out some practical advice on what should a medical practitioner do when they receive a request for patient health records. So as I just mentioned, firstly, identify the person requesting the records. If that person is not the patient, ensure that they have the requisite authority and consent from the patient. Check the patient's details that have been provided by the person making the request to confirm whether, in fact, this is even a person that you've treated, because sometimes these requests get misdirected. So check the patient details against your records and check and confirm whether you indeed have the records that have been requested. We advise that practitioners should refer any requests for records which they receive to their professional indemnity provider, because your professional indemnity provider has the necessary expertise to establish whether the request is compliant. That would be in terms of the applicable law in terms of the Promotion of Access to Information Act, and they can also assist with facilitating producing those copies of those records to the person requesting them. We also recommend that practitioners ensure that their practice admin staff are familiar with these processes and the requirements that need to be followed when receiving a request for records, because inevitably those requests will come to the practice admin email address, and those would be the first line of person dealing with those requests. So they need to understand these rules and guidelines and requirements as well. What to do when requests are made by attorneys on behalf of patients. So a request for records by an attorney must be made in writing, and it must comply with the requirements of PIA. A compliant request for records from an attorney who is representing a patient should include at least the following: a completed PIA Form C. This is the correct form for requests to private practices, private medical practitioners and private facilities. It should include a signed power of attorney or mandate from the patient that clearly authorizes the attorney to represent them and act on their behalf. A copy of the patient's identity document should also be included with the request, and a signed consent form from the patient specifically authorizing the disclosure of their confidential information to the person making the request. A practitioner who receives a compliant PIA request, that means that all of these criteria and documents have been submitted with the request, must make that information available to the requester within 30 days. We often get asked what must be by our practitioners, what needs to be included when I need to send the patient's records to them in compliance with the request, what needs to be included with those records that need to be sent. So a practitioner is obliged to provide a full copy of the entire patient file. This would include contemporaneous notes, whether those are handwritten or electronic, pathology results, radiological investigations, imaging, reports, photographs, Importantly, also WhatsApp communication and email correspondence with a patient also forms part of that patient's health record. Referral letters to and from other practitioners, informed consent documents, that would be surgical informed consent, consent to treatment, and financial consent forms, and any video recordings for any surgical procedures that have been performed. The records being sent must be complete and unaltered. Practitioners must remember the ethical guideline regarding the alteration, amendment, or addition to patient records, as was mentioned by my colleague Mashuma. This is a good place to remind the practitioners regarding the rules in respect of altering and amending records, and also a good example of why practitioners should not write any disparaging or personal remarks in a patient's folder, lest they get a request for the patient folder and it needs to be submitted to the patient, an attorney, the HPCSA, or court if the records become disclosable, and then that remark or inappropriate comment is contained in those records that need to be disclosed. At the end of booklet 9, the HPCSA does provide a concise and relevant and useful short checklist that kind of summarizes and contains most of the important provisions that we've gone through. So just as a brief reminder, records should be complete but concise. They need to be consistent. Any self-serving or disapproving comments should be avoided in patient records. A standardized format, it's suggested that one uses a standardized format with all their record keeping. That would include a chronology, a history, physical findings, investigations undertaken or advised to patients, diagnosis, treatment, and obviously any outcome of any treatment or procedures. If the record needs alteration in the interest of patient care, a line in ink needs to be put through the original entry so that it remains legible, and the alterations need to be signed in full and dated, and when possible, a new note should refer to the correction without altering the initial entry. Copies of records should only be released after receiving the proper authorization, as we mentioned earlier. Billing records should be kept separate from patient care records, and attached documents such as diagrams, laboratory results, photographs, charts should always be labeled. Sheets of paper should not be identified simply by being bound or stapled together. Each individual sheet should be labeled accordingly. I would move on to giving two case examples, which perhaps speak to some of the issues that I've discussed that can crop up when one receives a request for patient records. So a specialist was asked by a colleague to assess a patient in hospital. This was for purposes of investigating a large suspicious tumor-like mass on this patient's right foot. When the specialist examined the patient advised that the mass had actually been present for over 2 years, but he hadn't sought any prior medical treatment as he was taking herbal medicine. The specialist undertook all the requisite preliminary investigations, as well as performed an incisional biopsy to investigate the nature of the tumor and to formulate an appropriate treatment plan for the patient. The patient, however, remained non-compliant, obstinate, failed to adhere to the medical advice provided, and he later just failed to return for any follow-up and wasn't seen again by the specialist. But approximately 8 months later, the specialist received a request for his clinical notes in respect of this particular patient, and so he notified his insurer accordingly. When the insurer received a copy of the full patient file from the practitioner, it was found that the specialist had written within the contemporaneous clinical records as part of the patient records the following statement: "I refuse to see this idiotic patient again." As I'm sure everyone can imagine, that would be rather uncomfortable to now know that the patient himself, as well as whomever was assisting him with the request, would see such a comment within his clinical notes. The second case study relates to an HPCSA complaint, which really highlights overall the importance of thorough, good record keeping and the impact that it can have on mounting a defense and getting a a successful outcome in a complaint matter. So Dr. Patella was an experienced orthopedic surgeon. He received an HPCSA complaint relating to a knee replacement surgery performed on a 70-year-old patient who had osteoarthritis. Despite a doctor's expertise, complications did arise post-surgery, which led to prolonged pain and limitations in mobility for the patient. In gathering the necessary information and supporting documentation in preparing for Dr. Patella's defense against these allegations of unprofessional conduct which had been leveled against him, it became apparent to his legal team that his patient records were sparse, they were inconsistent, and they lacked sufficient detail to provide evidentiary support for his defense. While the patient had indeed undergone preoperative evaluations, surgical procedures, post-op management under the care of Dr. Patella, critical details such as consenting discussions, surgical techniques, the implant specifications, and the follow-up protocols were either inadequately documented or entirely absent from the records. When the HPCSA Committee of Preliminary Inquiry reviewed the complaint, together with Dr. Patella's response, they made some key observations specifically in relation to the issue of record keeping. These were that Dr. Patella's records failed to adequately document the informed consent process, including discussions about surgical risks, alternative treatment options, and expected outcomes. This oversight was deemed to undermine the validity of the patient's informed consent, and it raised questions about the adequacy of the doctor's communication with his patient. Doctors' records lacked comprehensive documentation of the surgical procedure, including the preoperative assessments, the intraoperative findings, and the postoperative complications. This deficiency made it challenging to ascertain the surgical approach taken and to evaluate whether or not the established protocols were adhered to. Crucial details regarding the patient's post-op recovery, including pain management strategies, wound care protocols, and the rehabilitation progress, were conspicuously absent from Dr. Patella's records, and this omission raised concerns about the continuity of care and adherence to post-operative guidelines. The deficiencies in Dr. Patella's records significantly undermined his defense, as he was unable to provide the necessary documentary evidence to support his clinical decision-making and his conduct. And ultimately, the HPCSA committee did find the doctor guilty of unprofessional conduct or for failure to meet the standard of care in the circumstances. Thank you very much for listening, and I hope that that was of some use and informative to our practitioners listening this evening.
Mashuma and Jessica, very, very good presentation. Thank you. Maybe just before we go into Q&A, it's just important to highlight one or two things. The first one is the questions that the SCPD by definition is for sharing in knowledge, education. It's not a legal opinion. So we must just be aware that if you've got specific matters, you wouldn't take the answers that you get given here as a legal opinion that you may use. For those people that really have got specific matters that may need a formal legal approach, you can always send those to either to your insurer. If you are insured with us, you can always send it to info@ethical.co.za. So whatever discussion that's going to ensue, please consider that as it's for educational purposes. It's not a legal opinion. The second point that I just want to make is that one of the frustrating issues, our claims team, they know this. It's very difficult to defend. It's very difficult to understand if we cannot access your records. And one of the most frustrating things within the team is health practitioners they don't become responsive in terms of supplying the required information. There is no HPCSA response or a letter of demand or a written complaint that you can be assisted with if there are no records, or if you submit those records a day before the deadline. So it's always important for us to try and request. The sooner you know that the records are required, please provide them as soon as possible. The third point before we go directly to the questions is that at the end of this session now, there's a survey that's going to come up your screens. Please complete the survey. The reason for that is, this webinar that we're holding now, it was based on a survey sometime that we did where the attendees requested that, can we please talk again around the medical records? We're trying by all means that all the webinars that we hold are webinars that are relevant, are webinars that have been requested by most of you. I would go to some questions that we dealt with earlier, some of those that were requested at the time of registration. I mean, obviously, Mashuma and Jessica would also be assisting in taking those questions. There are general themes that came out from those questions. The general themes were around electronic records versus manual records, where the question was that if we have electronic records, do we still follow the same approach, or do we need to still comply in the same way as the manual records? I'm not sure if Mashuma, you want to take this one. I'm putting you on the spot.
Thank you so much, Dr. Shlombe. Yes, you definitely are. So the question, was whether it is the same, whether when you're dealing with electronic records, is it the same in the same way that you dealt in terms of the guidelines as you would if it was a handwritten note. So in terms of booklet now, as I've actually discussed in my talk, regardless of the format of your records, the rules remain the same. There are certain guiding principles that I put on the slide there. It applies to both electronic or hard copy of records. And in the same way that you need to ensure that you are ensuring privacy and upholding patient confidentiality of hard copies, you similarly need to do the same for electronic copies. So the same reasons apply, Dr. Shlombe, to both. I'm not sure if there was any additional part of the question that I missed.
I think that is fine, Ms. Shuma. You follow the same rules that are prescribed within the booklet 9. The other question around electronic records that we got was which IT system or which product or which can we recommend? Which one is the best? Obviously, we will not be able to know that. Our advice really is that whoever says is doing health records from an IT technology kind of service, that person or that company must be aware of all the guidelines that are relevant, and you show them the guidelines, and they must ensure that they comply. And as a person who's consulted the company, it means that you also have to know exactly what is expected and be able to guide. But from our side, it becomes very, very difficult. The only thing that we always say is when you are unsure, contact us or contact your insurer, especially when it comes to the request for records. I think there's a lot of questions that we're talking to that. What do we do when there's a request for records? There were questions around deleting or making alterations in a record. I think both Mashuma and Jessica, you've addressed that. But the question was around clinical electronic records. What do you do? Can you delete? Because remember, it's very difficult. It's very easy to delete. And the question was, can you retrieve those records? Again, I know that forensic IT people, they're able to go back and find things that were deleted, the time when the records were deleted, who deleted it, where and when. So the IT questions are a little bit trickier for us, but it's an important thing that you know that there's no change in terms of the guidelines when it comes to electronic records. I'm not sure if, Jessica, is there a question that you like and you would like to take before I come to some of the questions that have been asked live? Do you have any question that, Jessica, you'd want to take from the ones that were sent earlier? Can choose anyone, Jess.
Thanks, Shlombe. I think I was just going to add to that, as easy as it may seem, and I'm no IT expert, so I'll full disclaimer, that, well, it's digital. We can just backspace, delete, make an alteration. We have seen court cases. So as plaintiff attorneys will hire the highest, most elite computer gurus, and they will be able to track the metadata behind what date those notes were originally created, when they were altered, who were they altered by, if there were any deletions, what they were. So there are ways and means, and they will do it. So it is very important to keep in mind that even if you are digital record keeping, like the guidelines say, put a line through the original entry, explain why you're making the change, what the reason for the change is, make sure the original entry is still legible, and then make the new entry, correct the information that was incorrect, and just explain it, and then date and sign it, whether that's with the digital signature, with your MP number, and just really follow the same guidelines and protocols with your digital records as you would with your paper records.
Yeah, I think there is a question exactly on that as we are presenting about, it seems like all the records are copies of physical records. It's always important that, when you do those alterations, you maintain the integrity of the record. You maintain the accuracy, the traceability. So it's always important because they must also consider your audit trail, because whoever makes those changes, even if it's electronic, there's a way of checking what happened to the record. Therefore, it's one of the most important things that we cannot just run away from what is expected by the guidelines only because we're using electronic records. So the rules are still the same. The other question is, what does financial consent entail? What does financial consent entail, Mashuma?
Thank you, Dr. Shlombe. So financial consent is really in the same way that in surgical informed consent, you would put the patient in an informed state to be able to see whether they are comfortable with accepting whatever complications, risks, benefits, and cost implications that there are. When it comes to informed financial consent, you similarly also need to make sure that you apprise the patient of whatever consequences or financial implication for the treatment that you provided to that patient could be for them. Even if it's rough estimates, that you actually need to make the effort that you apprise them of it. It's always helpful if a patient understands that in addition to the service that I provide, there might be an anesthetist that will bill you separately. It might also be a situation that the hospital fees are separate to mine. If the patient can be informed and understand that and sign any practice documents detailing that they've consented and understood this, later down the line, you're less likely to receive complaints that you're unable to deal with successfully because of some possible lack of informed financial consent. So it's really just putting a patient in an informed financial state to be able to make decisions regarding whether they can afford whatever service you're providing to the patient, as well as, importantly, any alternative options and any estimates that could possibly flow from that treatment.
That's a very important point that you are making. because you would know that we do receive a lot of billing related information or billing related complaints, be it written complaints or be it HPCSA complaints. So the advice is very important that in the practice, patients must know the financial policy, or they must give the financial consent or the billing policy of the practice. It is a very important one, because when we deal with doctors, they would say, well, the patient would start by saying, I want my money back. And the doctor says, no ways, I did spend time, assisting you. But when we check, sometimes we'd find that the financial part of the relationship between the doctor and the patient was not very clear. So that point really talks to ensuring that it's very clear what the financial or the billing information or the billing terms and conditions are for your practice. There's another question here in, can you bill a patient or somebody or a lawyer or whoever who requests your records? Can you say pay for my records? I think, Jessica, you spoke about pay. Do you bill the patient or do you bill the
Thanks,
the lawyer?
Dr. Shombe. Yes. Yes, if attorneys are requesting copies of patient records on behalf of a patient, you may charge them a tariffed rate for the time spent to create those photocopies, an administrative fee, as well as the photocopies themselves, or the time spent to scan in those documents if you are just sending them via a digital PDF and not actually providing them with hard copies. So the provisions of the Promotion of Access to Information Act do make provision for reasonable costs. Practitioners are also entitled to charge, for example, writing a summary treatment report. Reasonable fees for professional time spent is accepted. So yes, that can be charged.
Thank you. I'm just thinking about charging a patient for your records. I wonder how the
patient themselves. No,
yeah.
the patient is entitled for access to their medical records. So it's usually we see that the reasonable fee request is when it comes from an attorney or a third party. But when the patient themselves requires access to their own medical information, the practitioner is obliged to provide that.
If it's a record that you need to write, for instance, sometimes there may be an insurance disability claim or something.
Yes.
Can you
charge for completion of specific reports, so PMA benefits, workman's compensation forms, or a specific insurance form, or completion of documentation. But again, this is where being forthcoming with the financial implications, that the patients just need to be informed, whether that's by the practice manager or secretary or by the doctor themselves, that what they are requesting will be charged for and exactly what that cost will be to them for the doctor's time to complete those necessary forms.
There are several
and for a medical report as well. So say not just a photocopy or a scanned in copy of the handwritten notes. If the patient is specifically requesting a typed report, again, a reasonable fee for the time that it takes to prepare that typed report.
I think there were several questions that were asked regarding how long should patient records be kept, and I think those were addressed in the presentation, and they are very clearly written in the guideline. So we'll not address that question. It's been addressed throughout. The interesting question that came through again was, you see this one patient, it's a once-off. We've never seen this patient. Do you still need to keep the records for 6 years minimum? I think that's basically the question, to say you see this patient once and you never see that patient again. Do you need to still? The answer is yes. Yes, you need to keep that record. I mean, I can understand from a clinician's point of view that maybe this is a patient that was passing by, driving from Limpopo, and is in Joburg, consults for a certain condition, and you treat that patient as a once-off, and the patient disappears. But you still need to comply to what is required in terms of the duration of when do you want to keep the records. I'm just trying to check. It says here, what happens if a file is not found after many years? Any taker for that question? What happens if that file is just not there for many years?
So yes, not ideal. It does happen. It has happened. And especially a bit more tenuous when the requirements for the period of retention haven't been adhered to. But essentially what your attorney or your legal advisor or your insurer will assist the doctor with is the doctor would then need to produce an affidavit, so a sworn oath and statement, which would then recall the last time that they treated the patient, the last time that the file was seen or taken out of the cabinet, or basically to try and recreate or produce the reasons why the file may be missing. Perhaps it was archived, especially if it's been many, many years, and it was stored off-site or a practitioner moved rooms. It depends what the reason for the request for the file is, whether it's for an inquest process and it's a SAPS detective asking for the documents, or it's a patient or relative, but the doctor would need to make a statement and give an explanation and also to recount the steps that have been taken to locate the file, to show that all the options have been exhausted to try and locate that file.
Yeah, let's not lose them. I think that's a very
That's great advice, Dr. Schlomberg. Let's keep to that. Yeah.
Yes. There's a question here that says, why is video-based consultation not considered if detail and accuracy are that important? I think when we looked at, I think you did list what is included in a patient medical record in your presentation, Jessica. You did include videos, photos, notes. So it is considered. But I think what is more important for the video is to ensure that the patient is aware that you are taking the video, so that this consultation is being recorded via a video, rather than the patient not being aware that you have. And again, it goes back to the question around the electronic records, where you are able then to know where to store the videos, because the videos, they tend to be bulky in terms of the megabytes or in terms of the size of, your record. But if you have, storage, can be retrievable, can be audited, could be traced, the patient is given consent to be recorded. Because we must always understand also that the problem with that, once you record the video, the confidentiality becomes extremely high, because now the face of that patient is there, the condition is actually there. So it goes back to, what Mashuma and Jessica has spoken about in terms of security. So video is fine until you know that you comply fully and you put in extra measures to protect the confidentiality. Let's just check another question here. Personal notes, like those notes that you said, you addressed that properly, Jessica. There's a question here that we've addressed earlier that talks to Maybe I must ask this question. Maybe I would ask even maybe JP if he's still around, just to address. I'm not sure if everybody has seen this question. Can ICD-10 and CPT codes be regarded as to summarize long phrases and notes, specifically in surgical environment? This is something for me that I felt maybe you don't want to just to summarize and you write a CPT code or an ICD-10, right? Are you able to address that, JP, if you're still around with us?
Hi, Shlombe. Yes, I can. In short, I think yes, ICD-10 and CPT codes are specifically designed to summarize detailed medical information, including diagnosis and procedures, into standardized codes that are widely understood in the medical and legal field. So not only streamlines the record-keeping process, but also ensures consistency and accuracy in the documentation of medical and surgical care.
All right. Thank you very much, JP, with that. I see that we have 5 minutes. I mean, the webinar is supposed to be ending at 19:30. And I know that it's winter in Johannesburg, not sure in other parts of the country. So in the last 5 minutes, I really would want us to just to emphasize again the point that please ensure that your MP number is correct or your council number is correct when you've registered. You can go back and access the webinar. Please don't forget to do the survey at the end of this webinar, because that survey assists us and you in terms of the next webinar, the topic that we need to deal with. And please ensure that we have not given you any legal opinion. If you have other questions and any other thing, please talk to your insurer. Or if you are insured with us, send the request to info. And I would want to really thank our presenters, Mashuma, Jessica, and the background people that have really helped us to run this webinar. Mattiswe, JP for always being here, Joe. I mean, you know that when we prepare for these webinars, there's a lot of work that goes in. And there are questions that actually have not been addressed here, but these are the questions that we can still address if you send it to us at a later stage or you send it to your insurer. What I do not want to do is to take more time than is necessary in winter. So we've got about 3 minutes left. Maybe we can take just one last question so that we have 1 minute to do the survey. Any question that one is interested in addressing? Anyone? Mashuma, last one. Jessica? Just one question that you may want to see and address. There was a question around the psychiatry here that was very interesting for me.
I was looking at the questions on the Q&A chat,
Yes.
and one where I just saw, regarding keeping a record of examination findings. If I don't record a negative finding on examination, for example, no rash was found on the skin, then it can be argued in court that I didn't look for a rash. So would it be better to use a checklist type of documentation such that all negative findings are documented to be looked for routinely, but it would save much time in documentation? I find that a very, very useful, very practical question from a medico-legal standpoint, because that certainly makes our lives infinitely easier when we need to defend a doctor. Checklists, standardized checklists are all amazing, and negative findings do also play a big role in a defense, especially interestingly the way the question has been asked, because if you don't write down that you have looked for a rash and ruled it out, if it's not documented, it didn't happen, and that is an unfortunate finding with the HPCSA. If it's not in the clinical notes and there's no documented evidentiary support to show that you also excluded certain differential diagnoses or certain findings by investigating certain things. And I think by having a standardized checklist, depending on your specialty, this normal things that you would look for in almost every standard patient exam would certainly make the process of ruling out those things quicker, and it would make documenting those things much quicker and easier. So I think that's a very useful suggestion, and would reiterate that negative findings or exclusions do also need to be documented and included in your patient record keeping.
Thank you, Jess. One last interesting one, Mashuma, for yourself.
Let me just. Thank you, Dr. Shlombe. I think maybe just to go back to the importance of electronic records and some things that I found, because what I noted initially was that there was some questions about which iCloud, Google Drive, which one should we use? And you've already mentioned that, we're not IT professionals, but there are certain things that you can look at. So I think in that, maybe just to reiterate the importance of how you need to go about ascertaining what you should use is to maybe, first of all, use the guideline as your basis. So whether it's an electronic record or a hard copy records, the rules are the same. And we know that you mustn't just ensure that the privacy and security of your records, but you must set up control measures to also ensure that there's this secure and protection against unauthorized access. When it comes to this electronic data, in terms of the guideline that it must be kept, stored, and managed at this international standard. So what you can do is use this as your base, and then go and see a professional, and then do your due diligence, research what they offer, whether they are compliant with these standards that they should be, and whether they suit, what you need for purposes of compliance with the records. And I think if you can do that due diligence, make sure that what they're offering is that the information or data is encrypted. Make sure that there's these backup disaster management plans, that there's this audit trails you can regularly go and check who's accessed the records and things like that, and be very intentional about protecting the privacy and data. Then that's always a good and advisable thing to do, to be able to later, in light of any allegations, to be able to justify, your conduct. I think that was just maybe something I wanted to confirm.
Thank you. Thank you very much, ladies and gentlemen. And to all the attendees, we're really grateful that you attended this winter evening. Please don't forget to complete the survey at the end. It will help us and it will help you in terms of, and apologies to some of the questions that were not addressed. We would have loved to continue until 8 in the evening, but because of winter time and also just respecting everyone else's time. Thank you. Thank you to the presenters and thank you to everyone. Thank you.